Welcome. Good morning. My name is Erwin Chemerinsky. I'm the Dean of the Law School at the University of California, Berkeley, and I'm the immediate past president of the Association of American Law Schools. I'm joined this morning by my co-chair for this program, Mark Alexander, the Dean of Villanova Law School and the current president of the Association of American Law Schools. Last spring, when the Supreme Court granted certiorari in two cases about affirmative action, it seemed likely that the law would change dramatically in this area. After the oral arguments on Monday, October 31st, that lasted 5.5 hours, I don't think that anyone, liberal or conservative, doubt that the Supreme Court was going to change the law with regard to affirmative action. Mark, Judy Erwin, the executive director of AALS, and I thought it important to have a program for law schools on what can be done to achieve diversity after these decisions. This, of course, is of vital interest to all law schools, public and private. We predicted that the decisions likely would come down towards the end of the term. That prediction was accurate. They came down on the next to the last day of the term, on Thursday, June 29th. We also predicted correctly, as did everyone, that they would significantly change the law in this area. We decided to schedule this conference for early July, so the opportunity for people to read and digest the decisions, and also for us all to think about what are they likely to mean. I want to take a moment at the beginning to thank Judy, Tracy Thomas at AALS, and all the AALS staff who worked so hard to put this program together. I want to thank all of the speakers who are volunteering their time today to be part of this program. Enormously grateful to them. And I want to thank all of you for participating. A large number of people signed up for this program, reflecting its crucial significance. Let me describe how we're going to organize the day and our focus. The first program is going to focus on what did the court decide? What exactly did the court hold? What did the opinion say with regard to the reasoning behind the decision? This session will go from now until 12:30 Eastern time. We'll then take half hour, what's called on the schedule lunch break. That, of course, reflects an East Coast bias. For those like me on the West Coast, we can think of it as a coffee or a bagel break. But then we'll come back at 1 o'clock Eastern time and focus on what has worked and what hasn't worked in those places where affirmative action is eliminated. Some states, by voter initiative, had previously eliminated affirmative action. California voters did this in 1996 in Proposition 209. States like Michigan and Washington State have also eliminated affirmative action. Those in these states have a good deal of experience of how to achieve diversity without affirmative action. And it seemed important to share their wisdom, their experience with others. We'll then take a 15-minute break. We'll come back for the last session at 2:30 Eastern time to 3:45 and focus on what are the issues that are left open. There's so much that's undecided by the Supreme Court's decision on June 29th. We'll have a panel of experts to talk about where are the areas that are unresolved, where there still might be experimentation by law schools. What kind of litigation might we see? We'll then take a few minutes for concluding thoughts, and then the goal is that we'll finish at 4 o'clock Eastern time. We will leave time in every session for questions and answers. We certainly want as much discussion as the Zoom format allows, but please put your questions in the Q&A feature, not in the chat feature, and the moderators for each session will get to as many of the questions as possible. So with that, Mark, let me turn it to you for any introductory remarks before we begin.
Thank you for kicking us off, Erwin. Thanks again to everybody. Erwin just mentioned it is exciting to be able to have this conversation. And I just want to echo what Erwin was saying. And as I've looked at this, what I think is going to be really interesting about what we're doing is that we're not just talking about the law in the context of how we as lawyers and professors discuss and debate the proper way to interpret the Constitution, for example. When we have very high profile cases, we do that. Sometimes also we talk about cases that are very important in public dialogue. And that's always interesting for us to make sure we are engaged in public conversation. But what I think is really interesting here is that there's another dynamic, of course, and that is this is directly about what we actually do. As a contrast, for instance, the Dobbs decision last year, great questions of constitutional interpretation, very much in the public eye. But in this context, we are in the business of educating students. And of course, in order to educate students, we need to admit students. So this has a direct bearing on what we do in our daily lives as law schools, law professors, law school administrators. So I'm really glad we're able to have this conversation. And it was important to us. It was very important to us to think at the time, as Erwin was saying, about how can we be most helpful? How can AALS be most helpful to all of our member schools, all of our faculty, all of our administrators who are all part of AALS? So I'm really glad we're able to be here today. And I think the last point I'd make, and again, sort of echoing Erwin, is what we did know is that there were general fault lines, ideological perspectives that were laid out before the argument, certainly seen at argument, understood in the briefs. So there wasn't really a huge wonder of what was going to be the final ruling, who's going to win and who's going to lose. Obviously, anything could happen. But I think what's important is we want to be able to be responsive quickly to think, given what the court has said, what does that mean for us as we go forward in our work as law schools? And so I'm hoping this is a wonderful opportunity for us to think broadly about the law, but also think specifically about how we do our jobs. So I'm grateful for everyone who's here, and I will turn it back over to you, Erwin. Thank you.
Thank you. Thank you so much. Our first session this morning focuses on the decision that came down on June 29th in Students for Fair Admission for President Trustees of Harvard College. What we want to focus on is, what did the court hold? What didn't it decide? What's the law at this moment in time? I begin this discussion by focusing on 4 questions. First, it's important to begin with, what was the law prior to June 29th, 2023? Second, what did the court hold and why? What do the opinions say? How did the law change? Third, what was and what wasn't decided by the court? And fourth, so we're taking a moment to reflect on, based on the experience in states that eliminated affirmative action, what are these decisions likely to mean? I want to echo something that Mark just said. Our focus in this panel and through the day is much more descriptive than normative. What we want to do in this panel is describe what the Supreme Court said and what it means. And the subsequent panels to talk about what can and can't be done, what's left unresolved. We don't foresee this as being about a normative analysis, but whether the decisions are good or bad. It's much, as Mark just said, more of a practical focus, trying to do everything we can to help each other as we go forward to achieve diversity without affirmative action. So let me go to the first point that I identified. What was the law before June 29th, 2023? It's familiar to everyone, yet I don't think it's possible to understand what the Supreme Court decided, except in the context of what preceded it. The story has to start in 1978 with Regents of the University of California versus Bakke. It involved the University of California Davis Medical School. It had 100 students in entering class. It set aside 16 students in its entering class for students of color. It said that it did this because on past experience, had it not had some form of affirmative action, it averaged less than 1 Black student or Latinx student a year in the entering class. Alan Bakke, a white man, was denied admission to the University of California Davis Medical School, and he sued, challenging this. The Supreme Court was split 4-1-4. And it's interesting in reading some of the news accounts after the recent decision, they present Bakke as if there was a holding of the court And in reality, it was a very splintered court. 4 justices would have used intermediate scrutiny and would have upheld the entire University of California Davis Medical School program. These 4 justices said there's a profound difference between using race to disadvantage minorities and using race to benefit minorities. Rather than the usual strict scrutiny for racial classifications, they said intermediate scrutiny is appropriate for affirmative action programs. Instead of it having to be a government action, it being necessary to achieve a compelling purpose, it would only have to be substantially related to achieving an important purpose. 4 justices would have struck the entire program down based on Title VI of the 1964 Civil Rights Act. Title VI says that recipients of federal funds cannot discriminate on the basis of race. And of course, it's Title VI that was the basis for the challenge against the Harvard Affirmative Action Program that the Supreme Court decided 10 days ago. These 4 justices wouldn't have reached the constitutional question at all. They said Title VI precludes consideration of race. That left Justice Lewis Powell. He said that colleges and universities have a compelling interest in having a diverse student body. He said college and universities can use race as one factor among many in admission decisions to benefit minorities and enhance diversity. He pointed to a Harvard College program that does this as a model for how it can be done. He agreed with the 4 more liberal justices in intermediate scrutiny that Title VI and equal protection mean the same thing. And that, of course, has been crucial ever since, including in the Harvard case, that whether it's a public university that has to meet the requirements of equal protection of the 14th Amendment, or a private university that has to meet the requirements of Title VI when it receives federal funds, the standards are the same. But Justice Powell also said that quotas and set-asides are impermissible. Justice Powell's opinion set the path for all of the litigation about affirmative action in higher education ever since. Justice Powell rejected the idea that colleges and universities could engage in affirmative action to remedy the general social history of discrimination. He rejected the argument that college and universities could engage in affirmative action to provide role models for African American or Latinx students. Rejected the idea that college and university engage in affirmative action to increase services to underserved communities. He made clear that the only justification for affirmative action that was permissible was to achieve diversity. Now, if it could be proven that a particular school itself discriminated, then there could be a remedy against that school. But beyond that, what the Supreme Court, through Justice Powell, was saying, and the reason I focus on him is he was the pivotal opinion, was, and this is what the law seemed to be after Bakke, college universities could use race as one factor in many in admissions decisions to benefit minorities and enhance diversity. There couldn't be quotas or set-asides, and the standard would be the same whether it's a public university or a private university, the former under equal protection, the latter under Title VI. It was not for another 25 years that the Supreme Court returned to the issue of affirmative action in higher education. The court, to be sure, had become much more conservative in the intervening years. The court had handed out other decisions that had limited affirmative action. City of Richmond versus J.A. Croson in 1989, Adirondack Constructors versus Pena in 1995 had made clear that strict scrutiny is to be used for affirmative action programs. Those very much limited affirmative action in the government contracting context. But it wasn't quarter century after Bakke until Grutter versus Bollinger in 2003 that the Supreme Court returned to the issue of affirmative action in colleges and universities. Grutter involved the University of Michigan Law School. It followed what Justice Powell prescribed. It used race as one factor among many in admissions decisions. The Supreme Court, in a 5-4 decision, upheld the University of Michigan Law School program. Justice Sandra Day O'Connor wrote the opinion for the court. She talked about the importance of diversity in education, in classrooms and on campuses. She pointed to the experience of the military and how it had learned of the essential importance of diversity. She spoke of the need to give deference to the leaders of colleges and universities in making the choices about the composition of their classroom. She reaffirmed exactly what Justice Powell had said. College universities have a compelling interest in a diverse student body. They use race as one factor in admissions decisions to benefit minorities to enhance diversity. Now, the question arose at oral argument in Grutter: how long will college universities be able to continue to engage in affirmative action? Justice O'Connor, near the end of her opinion, said that she thought that this would be appropriate for another 25 years. Everyone puzzled over why 25 years? Why not go back to 1954 when Brown was decided, or 1896 when Plessy, or 1868 when the 14th Amendment was adopted, or to 1787 when the Constitution was written that institutionalized the protection of owners of enslaved persons? I think the answer of why 25 years was that Bakke was 1978, exactly 25 years before Grutter in 2003. There was discussion among the justices as to whether the 25 years was dicta or holding. I remember saying at the time that if there was a majority of the court that wanted to continue affirmative action after 25 years, it would not feel bound by Justice O'Connor's limit. And if there was a majority of the court to overrule affirmative action sooner, they would do that too. The same day as Grutter, the Supreme Court decided another case, Gratz versus Bollinger. It involved the University of Michigan undergraduate admissions. It assigned points to various features in an applicant's profile. Additional points were added to those who were minority races. The Supreme Court declared this unconstitutional in a 6-3 decision. Chief Justice Rehnquist wrote the opinion for the court. And in a footnote, he reaffirmed the standard under Title VI for recipients of federal funds is the same as that under equal protection. There was one other major set of decisions with regard to affirmative action in college universities before the decision on June 29th, and that involved Fisher versus University of Texas, Austin. This case that actually came to the Supreme Court twice. It involved, obviously, the University of Texas. It noted a lack of diversity in its student body, so it created a top 10% plan. It would take the top 10% of all of the high schools in the state. It's since been changed to a top 6% plan. Texas is sufficiently racially segregated that would produce some degree of diversity. And one question that come back to and certainly talk about in the last session is whether or not such race-neutral programs like top 10% plans will still be constitutional after the court's decision in students for fair admission. The University of Texas realized, though, that just having the top 10% plan didn't yield the diversity that it desired. So it also, following Grutter, used race as one factor among many in admissions programs to enhance diversity to benefit minorities. Abigail Fisher, a white woman, applied for the University of Texas. She was denied admission. She enrolled in and graduated from Louisiana State University, but she said she was injured by not being able to go to the University of Texas. The Supreme Court heard the case for the first time in the fall of 2012. And in 2013, the Supreme Court said that a college or university that wants to use race as a factor in admissions must prove that there's no race-neutral way to achieve diversity. This was an 8-1 decision, with Justice Kennedy writing for the court. The case was then remanded back to the Fifth Circuit to apply what the Supreme Court had said. The Fifth Circuit on remand found that the University of Texas, Austin had sufficiently proven that there was no other way to achieve diversity but its affirmative action program. The Supreme Court again granted certiorari. They heard the case in December of 2015 and decided at the end of June of 2016. It was a 4-3 decision in favor of the University of Texas in reaffirming Bakke and Grutter. Why 4-3? Well, Justice Scalia had died that term on February 13th, so he wasn't on the bench when the case came down. Justice Kagan was recused because she had been involved in the case as Solicitor General of the United States. Justice Kennedy wrote the majority opinion, joined by Justices Ginsburg, Breyer, and Sotomayor. This was the first time in his career on the court that Justice Kennedy ever voted to uphold an affirmative action program. Justice Alito wrote a vehement dissent, joined by Chief Justice Roberts and Justice Thomas. Justice Kennedy's opinion reaffirmed college universities have a compelling interest in a diverse student body. They may use race as one factor in admissions to achieve that. They must prove that there's no race-neutral way to achieve diversity, and the court concluded that Texas had met this burden. Why then, just 7 years later, is the issue of affirmative action before the Supreme Court? Did the justices find some musty history of the 14th Amendment that led them to believe they made a mistake? And of course, the difference and the key to understanding what the Supreme Court did is the change in the composition of the court. Since Fisher, 3 new justices have joined the court, Justices Gorsuch, Kavanaugh, and Barrett, and they joined the 3 justices who dissented in Fisher to create the majority in Students for Fair Admission versus President and Trustees of Harvard College. So this then brings me to the second part of my remarks. What did the court hold and why? As everyone knows, there were actually 2 cases before the Supreme Court. The Harvard case was brought under Title VI. It was brought especially on behalf of Asian students, claiming that they were discriminated against as a result of Harvard's affirmative action program. The district court held a 15-day bench trial and ruled in favor of Harvard College, rejecting the claim that there was discrimination against Asian students. The United States Court of Appeals for the First Circuit affirmed, and then the Supreme Court granted review. The other case involved the University of North Carolina. It was brought by the same group, Students for Fair Admission. It argued, though, that the University of North Carolina affirmative action program denied equal protection. The district court, the trial, ruled in favor of the University of North Carolina, saying it was compliance with the Supreme Court's precedents. Before the United States Court of Appeals for the Fourth Circuit could hear it, the Supreme Court granted cert. Technically, it's called certiorari before judgment. It is worth again emphasizing that the University of North Carolina case is about equal protection. The Harvard case is about Title VI. If you read Chief Justice Roberts' opinion, and it is under the title of the case, Students for Admission versus Harvard College, he says both University of North Carolina and Harvard were denying equal protection. And technically, that's not right, because equal protection under the Constitution is what applies to the government. Title VI applies to all schools, public and private, that receive federal funds. Justice Gorsuch, in his concurring opinion, stressed this, focusing on Title VI. The Supreme Court reversed the lower courts, the First Circuit in the Harvard case, the District Court in the North Carolina case. It's interesting that nowhere in Chief Justice Roberts' majority opinion does he explicitly say, we hereby overrule Bakke, Grutter, and Fisher. In that way, it's different than Dobbs a year ago, where the Supreme Court expressly said it was overruling Roe versus Wade. But there's no doubt that the Supreme Court has effectively overruled Bakke, Grutter, and Fisher. The Supreme Court says that college universities cannot use race as a positive factor in admission decisions to benefit minorities. The court rejects the reasoning of Bakke, Grutter, and Fisher that college universities have a compelling interest in a diverse student body. The court certainly rejects any deference to school officials, which was at the core of Justice O'Connor's opinion in Grutter. Let me just read you a key passage from Chief Justice Roberts that leaves no doubt as to the holding. University programs must comply with strict scrutiny. They never may use race as stereotype or negative, and at some point they must end. Respondents' admission systems, however well-intentioned and in good faith, fail each of these criteria. They therefore must be invalidated under the Equal Protection Clause of the 14th Amendment. Just a few words on the specific opinions. Chief Justice Roberts wrote the majority opinion. It's important to remember that Chief Justice Roberts has been a strong opponent of affirmative action, race-conscious government actions since coming on the court. In 2007, he wrote the majority opinion in Parents Involved in Community Schools for Seattle School District Number 1. We famously declared the way to stop discrimination based on race is stop discriminating based on race. Chief Justice Roberts reaffirmed that strict scrutiny is the appropriate test. He rejected any deference to college and university officials. He rejected that diversity is a compelling government interest. Remember, that was the core of Justice Paul's opinion in Bakke, of the court's opinions in Grutter and in Fisher. He said that diversity is too amorphous as a goal. It's impossible to measure what it is or when it's achieved. He says that the effect of the Harvard and the North Carolina programs is that it uses race as a negative, giving a benefit to some based on race, he says, works to the detriment of others who are not accepted because of their race. He says that affirmative action is based on the false assumption that there's a homogeneity of views of students of color. He says that's an assumption. The Constitution doesn't end. He focused on the need for there to be an endpoint for affirmative action. He said that Justice O'Connor and Grutter acknowledged that this had to happen, said within 25 years, and that time has essentially elapsed. At the end of his opinion, Chief Justice Roberts said something that will be enormously important to all law schools in their admissions process and to all colleges and universities. Let me again read it to you. Nothing in this opinion shall be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. So though a benefit cannot be given in the admissions process on the basis of race, a law school can consider race when it's raised in an essay as to how an individual overcame discrimination or inspiration. But then in the next sentence, Chief Justice Roberts qualifies this. He says, but despite the assertion of the contrary, universities may simply establish the application essays, other means, the regime we hold lawful today. What cannot be done directly cannot be done indirectly. A benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination. Or a benefit to a student whose heritage or culture motivated him, her to assume a leadership role, or attain a particular goal, must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experience as an individual, not on the basis of race. And I think as law schools, as college universities go forward, it's important to focus on that language from Chief Justice Roberts as to what's permissible and what's impermissible. Just a word about the other opinions. Justice Thomas wrote a long opinion that was concurring. Justice Thomas has long been a foe of affirmative action. And in this concurring opinion, he expressed his view that the Constitution requires that the government be colorblind. He recited the long history of race discrimination, and he drew his conclusion from it that the purpose of the 14th Amendment was to impose colorblindness. He talked about all of the costs of affirmative action. He especially focused on the stereotyping that occurs, the assumption that students of color are present only because of affirmative action, and how that hurts them. Justice Gorsuch, in his concurring opinion, as I mentioned, focused on Title VI. And it's important because Chief Justice Roberts looked at equal protection. Justice Gorsuch reminds us that it's Title VI that applies to private schools, but of course it also applies to public schools that receive funds. And the final concurring opinion was from Justice Kavanaugh. He focused on the language from Grutter that affirmative action was to end in 25 years. So it's been 20 years, and he says, we've reached the point where college universities should no longer be able to engage in affirmative action and use race as a factor in admissions. Justice Sotomayor wrote a dissent that was joined by Justices Kagan and Jackson. She stressed precedent. She talked about how the Supreme Court was overruling 45 years of decision. She emphatically rejected colorblindness as a constitutional requirement. She too reviewed the history of racism in the United States, of the 14th Amendment, and what got us to this point. She was quite powerful in her conclusion in terms of criticizing the court. And she wrote, and I quote, she said, the decision would have a devastating impact on enrollment of students of color. She says, today, this court overrules decades of precedent and imposes a superficial rule of race blindness on the nation. The devastating impact of this decision cannot be overstated. The majority's vision of race neutrality will entrench racial segregation in higher education because racial inequality persists so long as it is ignored. Justice Jackson also wrote a dissenting opinion, and it was joined by Justice Erwin Kagan. I should note, Justice Jackson did not participate in the Harvard case. She had recently been on the board of overseers of Harvard College, so she recused from it. She participated in the oral argument in the North Carolina case, but didn't participate in the oral argument in the Harvard case. So technically, the ruling in the Harvard case was 6-2, and the ruling in the North Carolina case was 6-3. Justice Jackson, as she did an oral argument in her dissent, contrasts two fictional students. She speaks of John, a white student who's the seventh generation in his family to go to the University of North Carolina, and James, a Black student who was the first in his family to go to college. And she talks about how it's a mistake and not at all equality to treat them the same. Justice Jackson wrote, quote, our country has never been colorblind. The lengthy history of state-sponsored race preferences in America to say that anyone is now victimized if a college considers whether that legacy of discrimination is equally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of equality that still plagues our country. As I read the majority opinion and the concurring opinions, and then the dissenting opinions, I think they disagree profoundly about certain questions. First, they disagree about whether using race to benefit people of color is the same as using race to disadvantage people of color. For the majority, the use of race, whether it's to benefit individuals of color or disadvantage them, is the same. Strict scrutiny is to be applied, no distinction is to be drawn. But for the dissenting justices, there's a world of difference between using race to benefit those of a group that's been historically disadvantaged, as opposed to using race to disadvantage them. Second, there's a profound disagreement over whether diversity matters. Chief Justice Roberts rejects diversity as too amorphous a goal to be a compelling interest under strict scrutiny. Justice Thomas, as he long has, rejects diversity as a compelling interest. But the dissenting justices very much embrace the importance of diversity in the classrooms and on campuses. And third, the justices disagree over the lessons to be drawn from history. My brief recitation of the opinions doesn't do enough to express how much they focus on the history. What's the lesson to be drawn from Brown versus Board of Education? For Chief Justice Roberts, it's that it's impermissible to use race. For the dissenting justices, it's how important it is that equal protection be used to remedy the history of discrimination. The justices disagree about the history of the 14th Amendment. Justice Thomas sees that history as embodying a requirement for colorblindness. Justice Sotomayor looks at the same history and says that Congress in 1868 created race-conscious programs like the Freedmen's Bureau that would show from an originalist perspective, affirmative action is to be allowed. The gulf between the majority and the dissent, like the gulf in our society between those who oppose and support affirmative action, is enormous. Well, let me shift to the third part of my remarks, and that's what exactly did the court hold and what didn't hold? I think the court clearly held that college universities cannot use race as a factor in admission decisions to benefit minorities and enhance diversity. In this way, as I said, it effectively overruled Bakke, Grutter, and Fisher. It did say, and I read that language, that it's permissible for college universities in reading someone's application and essay to consider how race affected their life as an inspiration or overcoming discrimination or otherwise, but this can't be a way to circumvent the prohibition the court imposed. What didn't the court decide? And I think it's important to focus on this because some of the news stories that I've read, I don't think get this right. First, the court does not preclude college universities from pursuing diversity, so long as they do so through constitutional means. I read some news stories that said that the Supreme Court has rejected college universities being able to pursue diversity. That's not what the court said. The court said colleges and universities can't use race as a factor in admission decisions to benefit minorities to achieve diversity. The diversity is not a compelling interest that permits this, but nothing in the opinion says that college universities can't pursue diversity so long as they do so through constitutionally acceptable means. Second thing that the court didn't decide is whether or not there can be targeted outreach and recruitment. I always think of the admissions process as having three steps. There's getting the students to apply, there's the decisions about admission, and then there's recruiting students. The Supreme Court's decision was about that middle step, what can happen in admissions. It doesn't speak to targeted outreach and recruitment, either in getting students to apply or at the stage of yield. Third, nothing in the opinion speaks about whether college universities can use proxies to achieve racial diversity. What I mean by this is, can colleges and universities use race-neutral means to achieve diversity? I alluded to this earlier when I was talking about Fisher and the top 10% plan. When the University of Texas said it would take the top 10% of all high schools in the state, that was facially race-neutral. Is that permissible? Justice O'Connor in her dissent stressed that colleges and universities can give socioeconomic status a plus in the admissions process. Now, whether or not that achieves racial diversity is a separate question, but she says it is permissible for college universities to give a benefit to those who are economically disadvantaged. What about programs that would give a benefit on the basis of a zip code, given residential segregation or the like? As I'm sure we'll talk about, especially in the third session, the question remains open as to whether or not race-neutral means can be used to achieve such diversity. They are facially race-neutral. On the other hand, if they're done with the purpose and have the effect of benefiting minorities, to then become a racial classification. Fourth, this decision isn't about hiring, recruitment of staff or faculty. There certainly are implications of this decision for that, but it is a decision about admission of students, and we'd have to just draw any extension of that by virtue of implication. And fifth, I think it's important, the majority never adopts colorblindness as a constitutional standard. Justice Thomas, in his concurring opinion, says that the 14th Amendment is about colorblindness. Here's why I think this is important. There are many laws that create liability on the basis of disparate impact. Title VII in the employment context, the 1982 amendments to the Voting Rights Act, the 1968 Fair Housing Law. If the Supreme Court were to embrace colorblindness, then it would put disparate impact liability at risk. Justice Scalia expressed this in a concurring opinion in Ritchie versus Stefano in 2009. He said that disparate impact liability requires that a decision maker take race into account in order to avoid liability. He said the court's going to have to face the question then of whether disparate impact liability runs afoul of the principle of colorblindness. This came up in another case this term in the court, Allen versus Milligan, that was decided on June 8th. It involves the Voting Rights Act. The state of Alabama said that the Constitution requires colorblindness, and thus states can't take race into account in drawing election districts. The Supreme Court, in an opinion by Chief Justice Roberts, expressly rejected that view, that in the context of voting, the Constitution requires that the government be colorblind. So as we think about what can and can't be done in education or other contexts, I do think it's important to note that never does Chief Justice Roberts' majority opinion embrace the idea of colorblindness. Well, the fourth and final part of my remarks, what are the implications likely to be of the Supreme Court's decision? Here, I think you can look to the experience of states like California, Michigan, Washington, where affirmative action was eliminated. As I mentioned, as you know, in 1996, California voters passed an initiative, Proposition 209, that says that the state and all of its political subdivisions cannot discriminate or give preference on the basis of race or sex in education, contracting, or employment. There's an immediate devastating effect on diversity in the University of California. Justice Sotomayor puts this in her dissenting opinion, and again, I can quote, at the University of California, Berkeley, and then she says, a top public university, not just in California, but also nationally, I'm quoting that, the percentage of Black students in the freshman class dropped from 6.32% in 1995 to 3.37% in 1998. Latino representation similarly dropped from 15.57% to 7.28% during the period at Berkeley, even though Latinos comprised 31% of the California public high school graduates. UCLA, for its freshman admission, had the same experience. The number of Black and Latinx students fell by 50% after Prop 209. It took UCLA 19 years until 2015 to get back to its pre-1996 levels of diversity. Justice Sotomayor talks about Berkeley. She says, for example, as of 2019, the proportion of Black freshmen at Berkeley was 2.76%, well below the pre-constitutional amendment level in 1996, which was 6.32%. Latinos comprised 15% of the freshmen at Berkeley in 2019, despite making up 52% of all of California public high school graduates. According to the briefs filed in the Supreme Court in these cases, 60% of selective public and private college universities engage in affirmative action. So the implications for public and private schools nationally will be enormous. And that's why I said there's a lot to be learned from the experience in California, Michigan, and Washington, and what we'll talk about later, what's worked and what hasn't worked in those states. So Mark, with that description of the cases, I turn it over to you.
Well, thank you, Erwin. Impossible to follow the master. I appreciate your thorough presentation of what transpired, and I certainly want this to be a discussion, and I want to highlight a few thoughts and comments. I think in the big picture, I think it is important for us to think about what the court did say and what the court didn't say. That certainly is a question. Again, there was no surprise that the court overturned, that it ultimately held 6-3, 6-2, the way it did. But the question is, what are the parameters they've been given? And sort of to the last point that Erwin was making, each school, every school, has its own values, its own priorities. What we have certainly seen in the wake of these decisions is a large number of universities who are saying, well, we value diversity, and that matters to us. And so that doesn't change that we value diversity. That's what so many schools have put out, so many statements that basically say something like that. And the question is how it is that schools might pursue that. Because what I think is very important to emphasize is that the court did several things. It was very clear about the inability for universities to use race to benefit students in admissions in that certain way. That was extraordinarily important. So if a university cares about diversity, racial diversity, then that university has now been told, here's a way you cannot pursue that. The court did not say that you can't have a diverse class. Of course, a court wouldn't say that. There's no way that a court would ever say you must have all students of one race or another race or certain numbers. The court wouldn't even be involved in that. They're not saying how many people of, again, however we want to define our diversity. They're not saying that we have to have a certain number of students of color or a certain number of white students or men, women, race, etc. So the question still that's out there is, what are the benefits of schools? So the court didn't, I want to emphasize, the court didn't say that you can't think about race ever. It didn't say what your values have to be, but it did say you can't use race in a particular kind of way. And I think that's just important to sort of sort that out. And I think to that point, another major point I want to emphasize here is that all of us who are here in this conference, and I think all of us throughout education, legal education, we all, when faced with this decision, have to consider whether our own individual programs fit within the constitutional declaration of the U.S. Supreme Court. That's ultimately we have to do that. And we all have our own priorities. We're all very different. Erwin's school is in California and is a public school. My school is in Pennsylvania and is a Catholic school. Private, very different, very different considerations. The populations who apply to his school and my school are different. The geographic regions are different. Public, private, religious, non-religious. So those things all matter. And we all in our own institutions have to decide how we live out our own values. And in that context, I think one overriding thing we have to say here is that whatever you hear today, the bottom line is you've got to talk to your own university general counsel about this. We're not going to tell you what to do within, what your lawyers might say, but we want to talk about, what are the avenues open if diversity is important to you. And the court made very clear how diversity cannot be achieved. And the question is still, how can diversity be achieved for those who want to achieve it? And so you do have to think about, outreach and recruitment and yield. I think that's an extraordinarily important point to emphasize. We do have to think about things like the Texas top 10% plan. That was, I think, a move that was made many years ago that people thought this is an interesting way for us to consider diversity in education. Because the reality that we know in this country is that we still remain very segregated in so many ways in our educational opportunities for kids. I'm not just talking university level, but as kids come up, there's so much different opportunity based, that then is ultimately segregated opportunities in so many contexts. Now, that may be from historical trends, that may be just the way that towns have developed over time. That may be through discriminatory intent a generation ago, 100 years ago. It can be for a lot of different reasons, but we know there are different opportunities. So I think the question is, are there other proxies perhaps that are out there? So I just wanted to ask that question, or put that out there for us to consider. Another thing which I think is important to consider is a question of, when I was just mentioning history, sort of trend to move from that point. I just was talking about, why are we in this situation where we see inequality in opportunity that so often breaks down on race lines? And that's something which to me is still very interesting in the way the court talks about this and the way they talk about race in general. And this goes back to another decision, Shelby County versus Holder. What the court there did, I think it's reminiscent of what happened here. And I think in terms of teaching con law and understanding con law, I think there's just such a great conversation between Chief Justice Roberts and Justice Ginsburg at the time in the Shelby County case, where Chief Justice Roberts says, look at all the progress we have made under the Voting Rights Act. And indeed, there has been great progress. When you look at a generation gone by, there has definitely been progress. The things that were done to deny people of color the vote 50 years ago, definitely so many of those obstacles are no longer present. And that is largely due to the Voting Rights Act, which was under consideration there. So he said, well, look at all the progress. We're now going to reduce the power, basically, of the Voting Rights Act. Justice Ginsburg says, no, we see the success of this tool, so let's not get rid of it. And her famous analogy, she said, is it's like going out in a rainstorm with an umbrella. You're not getting wet. So you say, I'm not getting wet. So you throw away the umbrella in the middle of the rainstorm. So that's just to say, I think here as well, you have different views of history and where we have come over time. And I think that's just really important to understand that the court is speaking in a way, and this does go back to what Erwin was saying, is also the idea of the value, the importance of race in society today, and how do you achieve your goals of an equal society? And when you're dealing with a society where there's inequality historically baked in. And this is something which is, I think, for us as law professors, I think such a huge question. For myself as a common law professor, Erwin as a common law professor, this is just a great question. I am very clear as I look at the Constitution. When I look at, there's clearly to me in the Constitution, in many ways, a promise of equality in the Constitution. Now the question is how exactly that plays out, and that's what scholars and judges and students will debate in perpetuity. But there's no doubt that there is a promise of equality contained in various parts of the Constitution. And so the Supreme Court, as composed today, sees it very differently than the Supreme Court not even that long ago, as Erwin was talking about when you look at the changed composition of the court. So we're in a situation where there's a fundamental question here of the court's view of history. Is there's a majority that looks at things very differently than the dissent. And there's, I think, frankly, a very big change in just the last decade. And it's I think, important just to recognize that there's different worldviews presented by the majority and the dissent, and we need to understand that as part of the foundation of what's happening here. One other point I want to make to emphasize this within these decisions is the question of color blindness in the Constitution. I think it's impossible to say the Constitution is actually color blind in that there are questions of race that are explicitly discussed in the Constitution. There's, you can talk about 3/5 clause. You can talk about freeing slaves, giving former slaves the right to vote, 13th, 14th, 15th Amendment. You can look at different ways, but race is part of the Constitution. There's no doubt about it. And what color blindness means is not clear. And I think that's, again, goes sort of to the worldview. So I think that there's no doubt that the one of the debates here is about what race might mean in our country and what we might do to respond to inequalities based on race in this country. But there's no doubt the Constitution addresses race, speaks of things related to race. So it's not necessarily this completely colorblind, and that's an interesting term. But what does it actually mean? I think that the point that the court wants to make is that, as we try to achieve equality, how can we look at race? And I think that's maybe what color blindness is supposed to mean. But I think it's important to understand, the Constitution talks directly about slavery and freeing the slaves and giving freed slaves the right to vote, treating slaves with equality. So it is contemplating race. And so I think that when we, I think that's just an interesting concept we have to consider. Where do we go from there? Where do we go from the fact that the Constitution said, in effect, ratifying the results of the war fought to eliminate slavery in this country? Where do we go from there? So we don't want to treat people with unequally. But that's not to say that we don't consider race in the Constitution. But I think there is a very strong question which they are presenting and which we actually still, of course, need to discuss here of what does that really mean? And so I think those are just, I think, several points I want to reemphasize. Oh, I'm sorry. The last one is also the time span, which ties in with the history point. You know, I think it's just a fascinating question, and I think anybody who was reading the decisions you know, over the last, reading the decisions that have been handed down in the last 70 years would see this clear generational issue of time. 1954, you know, Brown. 24 years later, 1978, Bakke. 25 years later, Bruder and Gratz. Right. So, you know, so you can say that's, you know, a generation in a sense. And now nearly 20 years later. So, you know, I think this is an interesting question. Like when we look at the span of history, and then we can, of course, go back, as Erwin did, look at when the, you know, 13th, 14th, and 15th Amendments were ratified. Or do we look back previous to that? What, you know, what is it that we see over time when there is change, societal change, and how does that have an impact on how we interpret the Constitution? And so I think that's just an interesting question to throw in there as well. So I think that was just to emphasize some points on top of Erwin's masterful presentation of the case itself. So I'll turn it back to you, Erwin.
Thank you. That was terrific. We have a number of questions and welcome questions in the Q&A. Let me just go through them. The first of the questions that we got goes exactly where you were ending, Mark. It says, what is the constitutional argument for a colorblind reading of the 14th Amendment? Based on what you said, let me say there's both an originalist argument that's made and responded to, and a policy argument that's made and responded to. The originalist argument is made explicitly by Justice Thomas in his concurring opinion in the Harvard College case. He reads the goal of the 14th Amendment as being a colorblind constitution. He very much rejects the view that the Equal Protection Clause was primarily about an anti-subordination principle. And he looks at the programs that were adopted at the time of the 14th Amendment and characterizes them either as race neutral, or he characterizes them as ones that would have met strict scrutiny. Justice Sotomayor in her dissent responds directly to that, explicitly rejects the idea that the original meaning of the 14th Amendment was a colorblind constitution. She points to the programs that were adopted at the time of the 14th Amendment and says things like the Freedmen's Bureau were very much race-based, and they would be thought of today as forms of affirmative action. As is true of most things with regard to originalism, one can make arguments on both sides with regard to the original meaning, and Justices Thomas and Sotomayor do. There is then a policy argument that's made as to why equal protection should be interpreted as colorblindness. You find this expressed in both Chief Justice Roberts' opinion and Justice Thomas's concurring opinion. What Chief Justice Roberts says is, if you benefit some on the basis of race, you're hurting others on the basis of race. Only so many students are going to be accepted to the University of North Carolina and Harvard College. And if some get a plus based on race, that means others aren't being accepted based on race, and they believe that that's wrong. Justice Thomas says, once you begin giving a benefit on the basis of race, that stigmatizes those who are students of color. People assume they've only been admitted on the basis of race, and it imposes harm on them, an argument that Justice Thomas had made elsewhere. They say from a policy perspective, equal protection should be interpreted to require colorblindness. Both Justices Sotomayor and Jackson respond to that. Each of them talk about the long history of race discrimination in American society. Each of them talk about the tremendous inequalities that continue to exist. And they say to be colorblind means we're not going to be remedying this discrimination, and it will continue. So those are what I see as the arguments on both sides in terms of interpreting the 14th Amendment that you find within this case. Mark, I don't know, you want to elaborate on that?
I would only emphasize also that Justice Jackson, I think, engaged in the debate in a very interesting and meaningful way. I think in the sort of the it was interesting in terms of trying to think about the original again. What is the original intent? And I think also just very interesting, sort of as a side note, that for her to be engaging this in her first term, she, I think, was far more engaged than quite often you see other justices when they first get on the bench. And I think for her, it was an interesting thing. It's just for court watchers to see how much she was involved in this discussion, this debate, and making her points quite clearly there.
And if you haven't read the opinions yet, for those who are listening, there is a sharp disagreement between Justice Thomas and Justice Jackson. Justice Thomas quite pointedly responds to Justice Jackson. Justice Jackson says Justice Thomas is accused her of creating straw people and that his arguments against her aren't really what she was saying. You've got to remember, Justice Thomas is only the second Black person to be on the Supreme Court, and Justice Jackson is just the third and the first Black woman. And very much they're writing from their own experiences, but draw such radically different lessons from them. The second question comes from our colleague, Dean Len Baines. He writes, Justice Thomas also said the court was overruling precedent. Why do you think that Chief Justice Roberts did not acknowledge that he was overruling Bakke, Grutter, and Fisher? Mark?
Yeah, I think that's an interesting question, Len. And I think it in part goes to I think in part it goes to the nature of Chief Justice Roberts. He seems in so many ways not to want to overturn precedent. Seems to, in so many ways, seems to want to stick with to respect the principles of stare decisis. Now, that doesn't always apply in every situation. But I think that he is, in some ways, he is, he wants to, perhaps as the chief, hold the institution of the court to a certain standard where it's not simply declarations of what they think is correct one day versus another day, and restrain the court from its from any decision to overturn precedent. I think it's a little odd because I think it is fairly clear that it is highly contradictory to those cases. This decision does not fit very well with those. So I think that I guess my answer is to say that I think it's perhaps that he wants to limit the amount of explicit overruling the court does, perhaps because of his view of the court institutionally, but at the same time, it is striking down so much of what those cases did. And I also would just use that to emphasize that as Erwin presented in his talk, cases that still stand. This doesn't talk about cases dealing with hiring and other areas where race is a factor in decisions that are made. And so perhaps he's trying to hold together some fabric around that.
I think it's a great question because there's no doubt that the Students for Admission versus Harvard College is overruling Bakke, Grutter, and Fisher. All of the other justices in their opinions, Justice Thomas and concurring opinion, Justice Sotomayor and Jackson and dissenting opinions, see it as doing that. And there's no doubt that Chief Justice Roberts wanted to overrule those precedents. So why didn't he say that explicitly? The only thing that I can think of, and it goes along with what Mark just said, is he felt he didn't need to say it explicitly because it was so clear that was what he's doing. And he didn't want to give the quote to the headline saying, court's overruling precedent. A year ago, the court's headline was, it overruled Roe versus Wade. And so here I think he felt he might be able to accomplish the same thing without giving the quote to the media and we're overruling precedent. I think there's something disingenuous about that. I think there is an obligation of candor on the part of the Supreme Court, an obligation for clarity. And I think by not saying what he was doing and just doing it, he failed in that obligation. The third question we get is, does this open the door to using disability as a proxy or positive factor to advance diversity? It's not a question that would in fact increase racial diversity.
I guess I would just chime in real quick. I think that in part the answer is this doesn't talk about that. This case, the case specifically talks about race, and to the extent that this is not covered by the court. So I think that there's no doubt that that we could. I think that the case doesn't decide that, and I think it would be what I think is going forward. We have to think about is, if you want to have diversity, I think then the question is how do you achieve it within these realms? I don't think the court says no, you can't consider disability. I guess I would also use that for a broader point. I think what's important when you talk about disability, I think that is a perspective. If one goes through life with a certain disability, then one has a different perspective. One goes through life, different races, different perspectives, different, grow up in different places, different perspectives. And I think what we all know, and I think regardless of your political perspective, your constitutional interpretation, when we are teaching, we get a benefit from having different perspectives in the classroom. And so I guess I would say that, I will always value having different voices in my classroom. And if that voice comes that way because of disability, I think that's going to add something to the classroom. And I don't think, though, that this decision specifically speaks to that very concrete point.
I think it's important here to focus on the law of equal protection. We're talking about public universities. The Supreme Court has long said, and emphasizes in this case, that strict scrutiny is used for racial discrimination, or race as a classification, and that it believed that the program failed strict scrutiny. But other kinds of discrimination or preference don't get strict scrutiny. So to take Justice Sotomayor's example from her dissent, preference on the basis of socioeconomic status only get rational basis review. The Supreme Court has held that discrimination on the basis of disability only has to meet rational basis review. That was the holding of City of Cleburne versus Claiborne Living Center. It was reaffirmed by the Supreme Court in University of Alabama versus Garrett. And so a program that fails strict scrutiny won't necessarily fail an immediate or rational basis review. Quite the contrary, rational basis review is so deferential that I think that preferences there are much more likely to be constitutional than not. So preferences based on disability, or preferences based on socioeconomic status, or preferences based on anything that gets just rational basis review are far more likely to be upheld. I guess the bottom line is what the Supreme Court says here is that race preferences violate equal protection because they fail strict scrutiny. That doesn't tell us anything about preferences where it's only rational basis review. The next question. We're also seeing questions regarding whether by implication and analogy, this case applies to scholarships where race is a criteria. Thoughts?
Yeah, I think that there will be there's an analogy, of course, you can say that this is specifically talking about getting in. And so in that context, I think a narrow reading would be that this is about admitting. That I think is a narrow reading. I think the broad reading is that if you were to take that to the Supreme Court, they may extend their reasoning here to that question. So I guess my immediate thought, and certainly not being anyone's lawyer, is that I don't think that the court says you can't do it. But at the same time, I think that if asked, then I think the court might extend its reasoning here. I think that the challenge, of course, also is that scholarshiping is yet again another level, and I think that's why it would be difficult to fully predict, because scholarshiping gets very complicated. We use it in so many different ways in so many different contexts.
I agree with Mark, of course, that this is about admissions decisions. It doesn't speak to scholarships. I can tell you that in California, the conclusion was that 209, which prohibits discrimination or preferences on the basis of race, also would preclude scholarships that are race-based. So we could not have a scholarship at the University of California, Berkeley, that would go just to African-American students, or just to Latinx students, or just to those of Asian descent. Now, again, this is based on language in an initiative that prohibits preferences, which might be distinguished from what the Supreme Court said. There are some lower court cases that invalidated race-based scholarships on grounds of equal protection in other jurisdictions. Now, one thing to keep in mind is this applies to scholarships that are administered by the school. If a private entity is giving the scholarship, of course, it can give money to whoever it wants, so long as it doesn't receive federal funds and violate Title VI. And one of the things maybe we'll talk about in the other panels is what's this likely to mean for scholarships. Bottom line is it doesn't answer that question, though there's certainly an argument that based on the Supreme Court's reasoning, it wouldn't allow scholarships that are based on race. The next question, Dean Chemerinsky, regarding what the court did not decide, you state that Chief Justice's opinion does not preclude college universities using diversity. Do you think it precludes using racial diversity? I want to distinguish here the goal, the end that can be sought, from the means that can be used. The Supreme Court's decision is focusing on the means. It says that colleges and universities cannot use race as a means to achieve diversity, but I think be one factor in admission decisions to benefit minorities. That's why I see it as overruling Justice Powell from Bakke and overruling Grutter and Fisher. It says that diversity is not a compelling interest that would justify that means. But nothing in the opinions say that college universities can't pursue diversity, including racial diversity, so long as they're using constitutional means to do so. And I agree with what Mark said a moment ago. College universities have always pursued diversity. It's always been easier to get to Harvard or Yale if you're from North Dakota or Montana than if you're Boston or New York. I taught at Duke for a while. My guess is that their basketball players might not have the same test scores and grades as other students because they believe that that's a skill that advances overall the quality of the university. That's diversity that was valued. So I don't think the Supreme Court is in any way precluding consideration of diversity, and I don't think it's precluding college universities from pursuing racial diversity. It's just saying the means that's been allowed since 1978 are no longer permitted. Mark, I don't know.
I completely agree. Well put. Thank you.
Next question. What do you think about the Stephen Miller letter that was sent to all 200 law schools?
I will say, if anyone wants to write me a letter with their opinion about how I need to act in wake of Supreme Court, I will assure them that I will always act within the, excuse me, I'll always act within the requirements, excuse me, sorry. I'll always act within the requirements of the law as declared by the United States Supreme Court, as the state of Pennsylvania, as the federal government, et cetera. If anyone has opinions about it, which Mr. Miller does, and they want to share them, that's fine. I will always ask my general counsel for how we are going to proceed to make sure we are acting, because to the extent that he or anyone else tells me what I must or must not do as the dean of a law school, the ultimate decision is that my general counsel will say that. I always welcome opinions. I think so. So I think that's, outside advice, you can always send it to me. And I think that the other part of it is just that I think, as we all know, this is a very highly charged issue. And so he sent a letter about this highly charged issue. And a lot of people have very strong opinions. And so I recognize that. And certainly as the dean, I'm very aware of that. And I understand that people have honest disagreements and strong ones. And so to the extent that any of the folks within my community have disagreements, I want to make sure we can all talk about those in as respectful way as possible and still understand we're going to move forward to pursue the values of our university consistent with the mandates of the law.
I'll simply say I agree with Mark. Of course, my law school, University of California, Berkeley, will always comply with the Constitution and always comply with state law in its admissions and its hiring decisions. I think what Stephen Miller's letter says is what all deans know. What we do is going to be closely watched, and there are going to be legal challenges against us. There's much, as we're going to talk about this morning, that's left uncertain for the Supreme Court's holding, and there's going to be litigation about it. But I think it's important that there also not be premature capitulation, that I think it's important that colleges and universities continue complying with the spirit and letter of the law to pursue diversity, understanding that some of it's going to be challenged in court and we might win some of those and lose some of those. I think all Stephen Miller's letter says is, we're watching you.
Mm-hmm.
Next
and
question.
I guess
Please.
let me just jump in there, because I was just looking at some of the questions, and I think that there is skipping this. We can get back to the next one, but the one after that from Michael Yalnowski, it's says technically it seems the school could continue to declare that it seeks a diverse student body, including a racially diverse student body, so long as it does not use race of applicants in isolation to pursue that goal. However, how dangerous from the standpoint of litigation risk do you think it will be for schools going forward to say proudly and loudly, we are seeking a racially diverse student body? I think that's just as I was looking ahead, I think that's we're kind of answering that as well. I think that we all have our values, and so any school can say what their values are, and they may say we're seeking a racially diverse student body. But I know, as Erwin just said and as I just said, we will pursue our goals no matter what those goals are. We're going to pursue our goals within the constraints of the law. And so I think the thing is that that you can say here are my goals, but also you say we will comply with the law, and that is absolutely true. We will always comply with the law. And so I think that that's going to be, I think, the question that everybody has. But I think if you say, like, I don't care, if you said I don't care about the law, the state of the law, well, that's a problem. But I think what you do say is, like, here are our values, and we will always comply with the law. But people are watching. Wherever you come down, people are watching. Sorry, I just was skipping it, looking at the questions for a second.
And I agree with you. Said, of course, there is a risk of litigation, and what each school, along with its general counsel and its president chancellor, decide is how much risk it wants to take. How much does it want to push the envelope? Some schools are going to be more cautious and maybe more cautious about declaring their goals. Other schools are going to be much more explicit and be willing to take more chances in terms of what's going to be allowed or not allowed in the courts. And as I say, that's going to have to be a decision that each school makes with its general counsel and its university officials. The prior question was, Erwin, it seems you're interpreting the decision to apply to all university admissions, not just undergraduate admissions. Am I correct? If so, why are you interpreting it more broadly? Bakke was about medical school admissions. Grutter was about law school admissions. Fisher was about undergraduate admissions. I see the Supreme Court is overruling all of those decisions and their allowance of affirmative action. Perhaps there's a way of arguing that there's a uniquely compelling interest for a particular school that will differentiate these cases about undergraduate admissions, but I think that's going to be a hard argument to make. I think that the reasoning of Chief Justice Roberts' majority opinion is likely to apply to admissions across various disciplines and fields.
Agreed.
Need to scroll down to the next question. What if a religious school, such as Dean Alexander's, determined that racial diversity is critical to its religious mission? Were they able to use the free exercise clause as a basis to continue its policy of using diversity as a plus in admissions?
Yeah, I would say that I think is a very important question. We I think in that context we could face a clash in a sense of values, and that as for us, we are an Augustinian Catholic institution. We speak about values of unitas, veritas, and caritas, and we recognize the unique gifts and talents that each individual brings to our community, and that's always been the case 180 years in, and we've always had a holistic approach that considers various factors, and And we believe that we are strengthened by individuals of diverse backgrounds. And we think that that builds on our own values as a Catholic Augustine institution. So I think that all of us will act on our values. And I think there is a very interesting question that I don't know the answer to. I think that's a great question, the one that's put into the Q&A. But I think that to the extent we are acting in pursuit of our Catholic values, then that does give a different basis for action. And getting into the question of would we be if we were not allowed to pursue those values, would that be a violation of our of our religious freedom? That is, I think, an argument that may still be seen, because I think that is very important. There are ways in which there's plenty of case law where institutions, educational and otherwise, act in pursuit of their religious values, and therefore have different outcomes than a secular or public institution might have.
To be more specific and more practical, I could imagine a religious school bringing a suit under the Religious Freedom Restoration Act, saying that prohibiting it from pursuing diversity using race as a factor is interfering with its religious mission, and that therefore there has to be a compelling interest. The question is, does equal protection there constitute a sufficiently compelling interest? I think it's an open question. I think it'd be right now, under current law, easier to litigate under the Religious Freedom Restoration Act than under the Free Exercise Clause, because under Employment Division versus Smith, you can't generally get exceptions from general laws on religious beliefs. But I think that bottom line is just what Mark said. It's very much an open question going forward. Many schools require or ask for diversity statements. This seems permissible given the decision. Is that correct? And if so, it seems that schools committed to diversity should ask for diversity statements. Take that one step further. Could schools use the decision itself to ask students directly, how has your race or other identity affected your life? The answer to that question is individualized. And the opinion states that admission officers consider individualized counts. I agree with that. I should say that the issue of diversity statements is in itself being litigated. There's a lawsuit that's been filed against the University of California, Santa Cruz, for diversity statements. And there's issues of whether or not it's compelled speech, issues of whether or not it leads to viewpoint discrimination. I think there are very strong arguments that it's not compelled speech any more than requiring other things like a job talk to be hired as a faculty member or an essay to be considered for admission does. And that what it's really looking at is what would you contribute. I think, to take your specific question, I think it very much would leave open being able to ask students directly, how has your race or identity affected your life? I go back to the sentence that I read from Chief Justice Roberts' majority opinion. Nothing in this opinion shall be construed as prohibiting universities from considering applicants' discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. Well, if college universities can still do that, why can't they then ask about it? Mark, I don't know.
I think, just to emphasize, that line of Chief Justice Roberts, I think, answers the question.
The next question, as I scroll down, how does this affect diversity pipeline programs such as UCLA Law Fellows in LEAD? It seems like they would not, but I wanted to get your opinion.
I would think that that's, to your point, Erwin, that you made earlier. There's, we are always trying to figure out how to make sure we have as rich and robust a population applying to our law schools as possible, and extending it to people of color, to first generation, to those with less opportunities, underrepresented individuals. And I think that's always going to be important to do for us to make sure that we get the strongest possible lawyers coming out of our schools. And I think that this does not in any way change that. I don't think.
I wouldn't want to speak about these specific programs because I don't know the.
Oh, no, not a specific program.
Right.
Sorry.
I just want to, but what I would say is I think there'll be an enormous difference between whether they are race blind or race neutral or race based. If they're race based and specifically say this is a program for Black students or this is a program for Black and Latinx students, then I think that there are going to be issues based on this. But if they're done in a race neutral fashion, then I think they're much more likely to be allowed. So when I was at UC Irvine, we created a program for college students from disadvantaged backgrounds. A student, in order to qualify for this, it was a program, you had to have a family income of twice the poverty level or less. It overwhelmingly was enrolled by students of color, but I think that that would be permissible. We created a program for high school students targeting particular high schools, but those high schools happen to be 99% students of color, but the program was itself facially race neutral. So my own sense is, so long as it is written and so long as it's executed in a race neutral fashion, I don't see a problem. If it is specifically race-based, then I do think any such program is going to be more suspect after this case.
And thank you. And thanks for that clarification. That is very helpful.
Would added value be a consideration? For example, the idea of cultural diversity of background. Think of growing up in a barrio.
I mean, I think that's also kind of what the Chief Justice says. I think that the Chief Justice says that you can ask how one's race has an impact on what their contribution is to the school. There are limits to how that, and as he very clearly states, that doesn't mean you can just say, if you are of a certain race, you get in. But I think that it is, I think, something that may be considered in the context of, as we were just talking about before, like something like a diversity statement.
And I see, skipping down a bit, there was a question about, will this affect pipeline programs? That's just what we were talking about.
Right.
I think so long as the pipeline programs are not race specific, so long as they're, for example, based on socioeconomic status or high schools, I think they're much more likely to be allowed. I think if they're just geared to a particular race or give a preference based on race, then I think it's going to be much more troubling. Another question, then I see we're running out of time, but have you heard of another Supreme Court case at an expiration date, the so-called 25 years in O'Connor's opinion in Grutter?
I always thought that was so interesting. I'm trying to think of examples of expiration dates. I think this was so particularly unique, and I think that the expiration date theory was always fascinating to me. And I think I would just emphasize what Erwin said before. The opinion of the court is going to be whether you have a majority fundamentally agreeing with the court going one direction or another more than an expiration date. But I think it was the point that I think that Justice O'Connor was making was, as we move forward in time, things do in fact change. And there's no doubt that in my mind, we are a better society in so many ways than the generation before that. We continue to make progress as a society. And I think that was sort of maybe a placeholder in that context. But I think it's ultimately what a majority of the court says, 25 years, 50 years, 100 years, that's what's going to be controlling.
Let me do this last question because I think it's a good place to
Okay.
sum this up. It seems like the court could have overturned the Harvard and UNC programs based on Bakke, Grutter, and Fisher precedent, disfavoring racial balance of quotas. I think that's right. And I think that the court didn't do so is quite important. The court might have said that Harvard and North Carolina didn't meet the requirements that were set out, especially in Fisher. They didn't prove that there's no race neutral way to achieve diversity. And had the court done that, it would have invalidated the Harvard and North Carolina programs, but on narrow grounds. That's not what the Supreme Court did. What the Supreme Court did was reject Bakke, Grutter, and Fisher saying that diversity is compelling interest. It rejected Bakke, Grutter, and Fisher saying race could be used as a factor in admissions decisions. I apologize we didn't get to all the questions. If there's a way for the AALS to keep the questions, if we have time in the other programs, we'll come back to these as well as take those questions, or maybe it's easiest just put your questions in the next time or in the other panel. We'll have time for that. Mark, thank you so much. We now
Thanks,
take
Erwin.
a half hour, what's called lunch break, and we'll be back at 1 o'clock Eastern time for the second part of the program, which focuses on what's worked and what hasn't worked in those places where affirmative actions were eliminated. Thank you, everyone. See you in a bit.
Thanks, everybody.